Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. The Medical Marijuana Act and the Medical Marijuana Card will, if you have one, will it affect and harm your child custody case? Let me tell you about a recent appellate court decision in Pennsylvania that bears on that very issue. In this case, the father had a history of recreational marijuana use and had struggled with substance abuse since he was 18 years old. The mother testified in court that the father is fixated on marijuana and grows marijuana plants in the home that he occupies. Father's heavy use of recreational marijuana was a factor in an earlier court order in this case, in which father was granted only supervised partial physical custody of his son, with the possibility of the lifting of the supervision requirement, according to the court, quote, upon father's willingness to demonstrate sobriety and continued abstinence, end quote. And by, among other things, he had to pass drug tests. If the father failed a drug test, the supervision requirement would not be lifted. Father obtained a Pennsylvania-issued medical marijuana card so that he could treat pain associated with a wrist injury. Father then went back to court and petitioned the court to modify his custody order on the grounds that the court should not hold his marijuana use against him. After all, he has a medical marijuana card to treat pain associated with a wrist injury. The custody officer who presided over the hearing issued a report and recommendation in favor of father. It recommended that the court, one, terminate the drug testing conditions on father's ability to exercise unsupervised custody, and two, significantly increase the duration and nature of father's period of supervised partial physical custody to unsupervised. Now, the maternal grandparents, who were the opposing parties in this case, filed exceptions to this report and recommendation from the custody officer. The trial court The exceptions are filed to the trial court, the judge, the court of common pleas, and he or she reviews the record and then renders the opinion, which is then the actual final custody order. In this case, the trial court ruled in favor of the maternal grandparents and reinstated the existing custody order with its drug-related conditions. Father wasn't happy and appealed to the Pennsylvania Superior Court. Father argued on appeal that the Medical Marijuana Act bars the custody court from considering any aspect of father's use of marijuana because he has a medical marijuana identification card. Now, father points to a particular provision in the Medical Marijuana Act, which provides, in pertinent part, custody determination. The fact that an individual is certified to use medical marijuana and acting in accordance with this act shall not by itself be considered by a court in a custody proceeding. In determining the best interests of a child with respect to custody, the provisions of the Custody Act shall apply. Now, it is true that the Medical Marijuana Act states that certified medical marijuana use shall not be itself, all by itself, be considered by a custody court. However, the Superior Court explained that the Medical Marijuana Act does not preclude the trial court from making relevant findings concerning the effect of marijuana use, whether medical or recreational, on a parent's ability to care for his or her child. In fact, the Medical Marijuana Act expressly states that the Custody Act and not the Medical Marijuana Act shall be used in custody actions. Thus, the Pennsylvania Superior Court affirmed the trial court, meaning agreed with the trial court, and the reinstated order with the various conditions related to drugs, abstinence, and drug testing, and that they remain in effect. So, in short, having a medical marijuana card may not be used solely and by itself as a factor against the card holder in a custody case. However, it does not mean that the cardholder's drug use or abuse, recreational or medicinal, cannot be examined and used as a factor in determining the best interests of the child. So do not think that because you have a medical marijuana card that your use of marijuana, recreational or medicinal, is off limits in a custody case. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.